or the events that may or may not have occurred with you and Mr. Duffy. And so I guess what I'm saying is if you produce that information to me, it may or may not have any relevance to these proceedings. And so if you're asking me to redact some of your personal information, if that's provided, I'll consider that.
In Your Honor, one of the things I'm a bit concerned about here is Ms. Eng has indicated her willingness to be transparent here, has indicated the breadth of information that she has contained on all of the computers, but I do think that there will be some just pragmatic difficulties with respect to Ms. Eng producing all of that, just given the scope of everything there, and the ability to simply say, well, this is the information I believe relevant, and then produced at the window will be only the documents she's able to print. It won't have any of the electronic information. And I understand Your Honor's burden with respect to
how am I supposed to, and how's anyone supposed to, unless you're looking to take copies of her computer? And I think that's
I think that is overbroad. I think that is overbroad as well, Your Honor. But the difficulty still becomes of the suggested method of discovery here of going through the in-camera review creates that additional burden, but also at the same point in time loses the opportunity that my client has to have a fair view of the relevant, potentially relevant discovery.
Well, I guess we'll see what we get, and if there needs to be, expansion of certain materials, if it appears insufficient or incomplete. I don't know what to say about that. I'm trying to keep it narrow.
Your Honor, may I say something?
Go ahead.
What I don't understand about the discovery replacing the shoulder of production on me, I'm the person that went to adult protection. I went to people working at Meals on Wheels who I'm concerned that there are other assaults that have been named about this individual. I'm the person that has been forthcoming. The only person who is sharing no evidence about his drug use, his criminal history, his use of a brothel in Italy, his attempting to buy drugs, his romantic life, all the women he is playing and attacking me when I wasn't even available to be attacked. None of that has come forward. Well, I do not seek to invade his privacy while this attorney seeks to invade mine. I actually only want from the respondent an explanation of the events in question, why he attacked me, what was his mental state, did he have mens rea for rape?
Okay, so let me just say, just discovery is reciprocal. You have the right to request discovery of respondent as well. I wish you had legal representation because I think that would help a lot.
Could I put a motion to continue pending Harbor gaining me representation? They have a new program for legal representation.
We are going to continue the hearing, the contested hearing.
Okay.
I still want to keep the deadline of July 12th just because it kind of keeps us moving forward here. And so that'll be the request, Ms. Eng, that you produce the discovery that you have available to the court for in-camera review.
And can I get a funding for that? I currently don't have any printer that is functional. I'd be willing to print everything I have, but I don't have the finances to help his client.
We're happy to provide a thumb drive if she'd like to simply place all of the information onto a thumb drive that I can provide to the court. That would save a lot of cost.
It would, and then our
IT person,
the court's technician could review it to make sure
there's no viruses.
Picking up any viruses. So that might be something that would.
Your Honor, it's more of a technical question I have on my old desktop attorney. My desktop computer, I had a memory saving device that recorded outgoing emails due to the attachment to my Gmail. So I have some records of his client's solicitation of me for this group event with Brenda, which he likes to mischaracterize as a date. I want his client to stop misrepresenting his attraction to me as a relationship, a date, a fling, whatever he has, because he's told many, many people he was dating me. And I want it to be clear for the record that I was never dating him. There was no date. There was an assault and an investigation, and there were multiple assaults, including the grabbing of my
I'm going to
wrist.
stop right now because we're not having the hearing
Right.
on the allegations. We're just talking about discovery.
And there was a threat to go masturbate after he pinned me on a wall.
All right, so I'm going to stop you right now because we're not going to talk about the allegations. What I would suggest is, Mr. Palmer, if you can provide a thumb drive to Ms. Eng, she can verify that it's blank. She can produce file transfers to that thumb drive or paper copies. I will look at them both. And if you can provide that by July 12th.
And what protection will I have that this information is not misused by his client?
The court is going to keep it and produce only what it believes to be relevant information or discovery relevant to these allegations, and that's what's going to be provided to Mr. Palmer with a directive that it not be redistributed. And so out of the materials, there could be 10 pages that is produced, or there could be 100 pages that are produced. I can't say without looking. And so that's what I'm going to do. And so I think July 12th might be a little bit ambitious, so I'm going to say July 19th. That gives 3 weeks. And then Mr. Palmer, when can you provide a thumb drive to Ms. Eng?
Today.
And that'll be provided.
We'll do it through the mail.
Okay. And so Ms. Eng, and Mr. Palmer is going to provide you with a thumb drive to use if you wish, to facilitate the production. Mm-hmm. And I have you produce what you can in accordance with the Exhibit 1 by July 19th. I'll get back to the parties as soon as I can after review, and then we're going to look for another date for our contested hearing. In the meantime, if there's a proposal for resolution, or if you have a counter proposal for resolution, Ms. Eng, put it in writing and communicate that court does not need to be involved in that.
What are the penalties for non-production?
Contempt.
Contempt of court.
Yes.
And so I'm being threatened with jail time for reporting a sexual assault.
You're being asked to produce information that might be relevant to a potential defense. You have the right to request information of respondent if that is your choice. Mm-hmm. And so I'm hoping that you'll follow court orders, and the court is going to be looking at your good faith. And what you produce. If there's something missing, or if there's something that the court feels is incomplete, I'll respond to you, or I'll respond to you, to both of you, and say, there appears to be more information. It wasn't produced. Could you follow up and produce that, please?
Could I ask that Christopher Palmer debrief me on his last 2 filings? Unfortunately, his harassment, which I believe to be proxy harassment by my assailant, has been so emotionally devastating to me that I did not open his last 2 filings, kind of like a bill that I'm not ready for.
Right.
And so I go into an extreme panic mode due to the severity of the assault and the way it re-triggers my 2002 rape, because of the very similarities of the 2002 rape with Christopher Duffy's assault. And I feel that I'm kind of left out of the loop of what he is proposing.
Do you have an extra copy of Exhibit 1? If you don't,
I can provide.
Is this May 31? Unopened?
Darla, could you go to the motion?
I believe there was one more.
May 31st, probably.
I think page 7 and 8
Okay, so this is...
We're gonna provide a copy of the Exhibit 1 that has the discovery request, and I'll give you that.
Thank you.
And so that's all I'm going to do today.
Your Honor, if I may ask a quick question with regard to you had proposed the option of a judicial settlement conference.
Yes.
Does the court have time on its calendar in the near future for something of that nature?
And I'm thinking it I'm not sure if you're asking for me to be the settlement judge. It might be best to see if there's another judge available.
I'll check with docketing then with respect to that and propose.
Do you think that would be helpful?
Potentially.
Ms. Eng, is that something?
McIntosh or Brownhill, or should we get an attorney outside who's not ruled on previous violence from men incidences?
Well,
I consider that your previous involvement with my previous assailant may prejudice you in my favor.
I would be happy with your honor serving as the
Well,
settlement.
I know Attorney AJ Wall is doing mediation in other matters. Maybe she would be.
I can't afford like a $12,000 mediation fee, but I've sought that, and
Again, Your Honor, and this is why I didn't mean to cut you off. I was actually going to say that the idea of the judicial settlement conference would be very cost effective to everybody involved. Would provide an opportunity for Ms. Eng to provide her story to the judge, for the judge to be able to listen to that, and maybe for a civil compromise to come between the parties at that point in time.
And let me just ask, Mr. Palmer, did you have you provided any sort of proposal for settlement to Ms. Eng?
The only settlement that I provided, or I did propose basically a civil no contact between the parties, and that the parties.
Did you draft it?
I did provide a.
I'm just wondering if. I'm going to step away here in just a moment, and if you wanted to.
Here. I don't know where it was at. I did provide it, and I do have a. Is it in that?
And Your Honor, just for the record, I am presenting a certified copy of the respondent's motion to compel production documents.
I got it.
And support.
Thank you so much.
Okay, and so if you take a look at, I think, the 7th page, Ms. Eng,
To the page.
it's an attachment to Mr. Palmer's motion to compel, and it's a 2-page document called Exhibit 1, and it lists 9 requests.
Okay. Good.
I just want to make sure you can find it. So that's the list. Do you see it right there?
I don't Facebook, Your Honor.
Okay, and so just a response to all of those questions: exists, doesn't exist, enclosed, attached. Just respond to each one and tell me what you've got and what you're producing, and that'll help a lot.
And after that, will we move towards the resolution of the whether or not you decide?
It'll happen at the same time.
And then could you clarify what he's speaking about when he's talking about a judicial? Was it a judicial resolution or judicial
Settlement conference? It's a time where parties get together with a neutral judge who doesn't have any involvement in the case or does have involvement with the case, and the parties agree, and then try to sort out.
And the goal is for me to drop my stalking order petition. Right.
I think the goal is to resolve the dispute in whatever way works best
Could I
with the parties.
stipulate what would be best for his client?
I'm not going to get involved in it at this moment.
Okay, so talk with him privately
if you
afterwards.
folks, we have conference rooms in the courthouse. If you want to take a moment and try to resolve it now.
If I may, Your Honor, I would be happy to produce the civil no contact agreement that we drafted and let her review it quickly.
Okay.
Oh, so it's a gag order to prevent me from speaking about the assault ever again? Maybe there's other stipulations I could add.
All right. So we're going to conclude this hearing, which is on the motion to compel.
An apology was all I wanted.
I'll do just a summary order outlining what my expectations are for production. We'll look for another hearing date. We probably need 3/4 of a day, I would imagine, at least. And Mr. Palmer, does it make sense to pick a date after the bar issue is resolved?
I unfortunately, when I originally spoke to the bar, they told me probably about 30 days. Next time I spoke to them, they told me probably about 2 or 3 months. It still has not resolved yet.
Right, and so that was, I saw the attachment to your motion with that communication. So Would we be looking at a date in September?
To be absolutely honest, I believe any time to move forward would be fine.
Okay.
At this point in time.
All right. So if you change your contact information, make sure the court is aware. If you are communicating about potential settlement, do so in writing. I'll check internally to see if we have judges available.
I would like to move for a settlement, but I also want to know, what do I do with my subpoena if the dates change around? I've never served subpoena before on the adult protective worker who took the wrestling
Pretty much
admission.
the subpoenas tend to continue.
Just continue. So
next
just
week.
keep her updated as to what the new date is if
Correct.
the dates get set out and out and out. Okay, and then how do we get this conference going?
Well, we'll have to see if there are any judges available, and that's something that I'll do behind the scenes.
And update us via mail?
I'm sorry?
And update us via mail. How will I know?
Correct, yes.
Okay.
Yes.
Okay, and so then just continue to work on the discovery, drop what I have off at your window?
Yes, I'd like it all together just so it
All
stays together. Instead of piecemeal, that would work better for me.
As I understand it, Your Honor, we are going to provide her a thumb drive. I was going to do it by mail today, so
Okay.
she should probably receive it within a day or two.
Okay.
A thumb drive for.
I think, Your Honor, I would like to drop this order, and not because I think it is for the good of society, but because it is for the good of myself.
And it may be.
This man's assault on me has been very
So,
traumatizing,
Ms. Eng,
but
hang
he's
on,
coercing.
Hang on one second. If you make that decision, you may. I
Yeah.
don't want you to make that decision right now because I feel like this is not the proper setting for you to make a good decision on that issue. But if you do, you'll need to make
I've
the
had enough
request.
with male violence, Your Honor, and I believe everything about this discovery is abusive. I will drop the order, and I have made my best faith attempt to alert the community about the danger this man poses, the violence he did to me, and he can walk a free man. There are many worse criminals than him,
Okay.
and we're done.
So
And you can find everything at wrestlingandtussling.blogspot.com.
and so, Ms. Eng, I'm not going to accept an oral dismissal.
Okay,
I want
so
you to
you will have the motion to compel, and then I have to go file with family court.
I want you to take a moment, gather your thoughts, and then if you do still wish to seek a dismissal of the stalking protective order.
Congratulations. He didn't rape me. We're good.
All right. And so make sure that request, Ms. Eng, is in writing.
Okay.
But I just urge you to take a moment and try not to react. And if you do choose...
I'm sorry I didn't scream, Your Honor. There were elderly women in the building. I got him out of the Owens-Adair apartments.
Okay.
He
And
did
so-
not attack anyone else that night. He pinned me to a wall
All right,
when
Ms.
I was
Eng.
investigating the case, said he would go masturbate. He will masturbate to the end of his days, to my data, and I will not give that data over under compulsion.
Okay, we're going to conclude this hearing. Ms. Eng, stay put. Mr. Palmer, let's have you and your party leave, and then we'll hopefully calm everyone down.
Yeah, sure.
All right, thank you, Mr. Palmer. Thank you, Ms. Eng.